Can you see this contract
Yes.
rider here, the condo rider, okay?
Yes.
Excellent. All right, so the condo rider contains required state law disclosures, addresses, associations, unit owner right of first refusal, special assessments, and buyer's request for documents. A lot of times the condo rider is used in additional to the HOA rider, because a lot of times a condo will be a sub HOA, if you will, to the master HOA. So on this rider, it's a fill in the blank addendum. You need the seller's line on the top, or seller's name on the top line, buyer's name on the second line, and then the property address. Buyer needs to execute. Seller needs to execute. Initials, both parties. Okay, and then I always liked to contact the HOA, and I'd ask them to walk through this with me, or ask them if they had a copy that they could share with me that was already filled out. Condominium association approval. The association's approval of buyer is or is not required. If approval is required, this contract is contingent upon buyer being approved by the association no later than blank days. By default, that's 5 days prior to closing. Within blank, by default, it's 5. Within 5 days after effective date, seller shall initiate the approval process with the association, and buyer shall apply for such approval. Buyer and seller shall sign and deliver any documents required by the association in order to complete the transfer of the property, and each shall use diligent effort to obtain such approval, including making personal appearances if required. If buyer is not approved within the stated time period, this contract shall terminate, and buyer shall be refunded the deposit, thereby releasing buyer and seller from all further obligations under this contract. Okay, so HOA approval needs to become part of your timeline when you're working a property or a transaction that falls within an HOA or a condo development. And you need to, if you're working with a buyer, you need to express that time is of the essence, and at the same time that they're delivering their escrow deposit, they need to be delivering their HOA application to the board. Okay. Right of first refusal. The association has or does not have a right of first refusal. If the association has a right, this contract is contingent upon the association within the time permitted for the exercise of such right, either providing written confirmation to the buyer that the association is not exercising that right, or failing to timely exercise such right pursuant to the terms of the declaration of condominium. Declaration, which reference includes the amendments thereto. All right, so certain HOAs or condo developments will have the right of first refusal, meaning that if they do not approve the buyer's application, they cannot purchase in there. That's why the contingency is added. The members of the association have or do not have a right. If members do have a right, this contract is contingent upon the members within the time permitted for the exercise of such right, either providing written confirmation to buyer that the members are not exercising that right, or failing to timely exercise such right pursuant to the terms of declaration. I can share with you that I once had a buyer under contract of a condo, and we actually had to extend closing due to the fact that the members had not had the time permitted to exercise this right, okay, they had not had their monthly board meeting yet. So we actually had to extend the contract because they hadn't reviewed my buyer's application. C, buyer and seller shall, within, by default, 5 days after the effective date, sign and deliver any documents required as a condition precedent to the exercise of the right, and shall use diligent effort to submit and process the matter with the association and members, including personal appearances if required. Okay, so this tells you that they need to move forward within 5 days. If within the stated if within the stated time period, the association, the members of the association, or both fail to provide the written confirmation or the right has not otherwise expired, then this contract shall terminate and the deposit shall be refunded to the buyer, thereby releasing buyer and seller from all further obligations under this contract. E, if the association or a member timely exercises its or their right, this contract shall terminate and the deposit shall be refunded to buyer, unless this contract provides otherwise, thereby releasing buyer and seller from all further obligations under this contract, and seller shall pay to broker the full commission at closing in recognition that broker procured the sale. 3, fees, assessments, prorations, and litigation. Condominium association assessments and rents. Seller represents that the current association assessment installments is or are blank, payable monthly, quarterly, semi-annually, or annually. And if more than one association assessment, okay, so if you have a sub and a master association, you're going to be entering more than one fee here, payable monthly, quarterly, semi-annually, annually. And the current rent on recreation areas is blank, payable monthly, quarterly, semi-annually, annually. Okay, sometimes you've got a sub, a master, a food and beverage minimum. Okay, all of those things can be conveyed here, disclosed there. All annual assessments levied by the association and rent on recreational areas, if any, shall be made current by seller at closing, and buyer shall reimburse seller for prepayments. Fees. Seller shall, at closing, pay all fines imposed against the unit by the condominium association as of closing date, and any fees the association charges to provide information about the property assessments and fees. If property is part of a homeowners association, see rider B, homeowners association community disclosure for further information, including additional assessments and fees. So yes, right there in big bold letters, if your condo falls in an HOA, you need the condo rider and the HOA rider or HOA disclosure, okay? Special assessments and prorations. Seller represents that seller is not aware of any special or other assessment that has been levied by the association, or that has been an item on the agenda or reported in the minutes of the association within 12 months prior to the effective date, except as follows, okay? Sometimes there's special assessments for irrigation. Sometimes, you know, they put a new sprinkler system in. There may be an assessment passed along to the residents for that. Or perhaps maybe the association recently had the roofs replaced on all of the condo buildings. There may not have been enough in reserves for something like that. And perhaps an assessment had to be imposed to the residents for that expense. Also, I can remember after Hurricane Irma, you know, a lot of associations did not have enough in reserves to cover some of the costs that were involved in repairs to the damages that were incurred from the storm. So again, a special assessment had to be passed along to the residents. C2 here, if special assessments levied or pending exist as of the effective date are disclosed above by seller and may be paid in installments, check 1. Buyer or seller shall pay installments due after closing date. If seller is checked, seller shall pay the assessment in full prior to or at the time of closing, okay? And if you leave it blank, by default, buyer is selected. If special assessments levied or pending exist as of the effective date and have not been disclosed above by seller, then seller shall pay such assessments in full at time of closing, okay? So if you're working with a listing and you're representing the seller, it is imperative that you do your due diligence and you definitely check. Ask title, hey, title, can you reach out to the HOA, see if there's any special assessments? I've done it a million times. You can have title work for you. They can do more than just simply close the transaction for you, okay? Or the other thing that I always do too, I call the HOA. I need to confirm fees. I need to know if there's any special assessments that are attached to this property. If after effective date, the association imposes a special assessment for improvements, work, or services, which was not pending as of the effective date, then seller shall pay all amounts due before closing date and buyer shall pay all amounts due after closing date. Okay, so let's say, you know, we're in the middle of hurricane season and you know, we get hit with some storm damage and, you know, perhaps an assessment is imposed to the residents. And this is after the effective date. We're in the middle of contract. That's where this right here outlines who is responsible. Okay. A special assessment shall be deemed levy for purposes of this paragraph on the date when the assessment has been approved as required for enforcement pursuant to Florida law and the condominium docket listed in paragraph 5. Association assets and liabilities, including association reserve accounts, shall not be prorated. Litigation. Seller represents that seller is not aware of pending or anticipated litigation affecting the property or common elements, if any, except as follows. So if there is some pending litigation, it needs to be disclosed, and here's where you do so. Sprinkler system retrofit. Pursuant to section 718.112(2)I Florida statutes, the association has voted to forego retrofitting its fire sprinkler system or handrails, rails, and guardrails for the condominium units. Then, prior to closing, shall furnish to buyer the written notice of association's vote to forego such retrofitting. Non-developer disclosure, check 1. Okay. Option A, the buyer hereby acknowledges that buyer has been provided a current copy of the declaration of condominium, articles of incorporation of the association, bylaws, and rules of the association, and a copy of the most recent year-end financial information, and frequently asked questions and answers document more than 3 days, excluding Saturdays, Sundays, and legal holidays prior to the execution of this contract. Or option B, this agreement is voidable by buyer delivering written notice of the buyer's intention to cancel within 3 days. Okay, you're going to give your buyer the right to the 3-day right to review, or are they going to accept as is? Okay. So option B, this agreement is voidable by buyer delivering written notice of the buyer's intention to cancel within 3 days, excluding Saturdays, Sundays, and legal holidays after the date of execution of this agreement by the buyer and receipt by buyer of a current copy of the declaration, condominium, articles of incorporation, bylaws, and rules of the association, and a copy of the most recent year-end financial information, and frequently asked questions and answers document if so requested in writing. Any purported waiver of these voidable rights shall be of no effect. Buyer may extend the time for closing for a period of not more than 3 days, excluding Saturdays, Sundays, and legal holidays, after the buyer receives the declaration, articles of incorporation, bylaws, and rules of the association, and a copy of the most recent year-end financial information and frequently asked questions and answers document, if requested in writing. Buyer's right to void this agreement shall terminate at closing. Buyer's request for documents. Buyer is entitled, at seller's expense, to current copies of the condo documents specified in paragraph 5 above. Buyer, you need to check one, either requests or does not request a current copy of the documents specified in paragraph 5 above. If this contract does not close, buyer shall immediately return the documents to seller or reimburse seller for the cost of the documents. Buyer's receipt of documents. Complete and check only if correct. Buyer received the documents described in paragraph 5 above on. Okay, if you're a listing agent, make it your prerogative to make sure that you have this one line completed when you deliver those documents to the buyer and buyer's agent. Make sure that the buyer's agent receives the buyer's execution on this. Okay, I would say delivered on such and such date, and I'd have all parties initial right next to that line, so there's no question. Common elements, parking. The property includes the unit being purchased and an undivided interest in the common elements and appurtenant limited, I probably pronounced that wrong, limited common elements of the condominium as specified in the declaration. Seller's right and interest in or to the use of the following parking spaces, garage, and other areas are included in the sale of the property and shall be assigned to buyer at closing, subject to the declaration. All right, if there's an assigned parking spot, put it here. If there's a garage, an assigned garage, put it there. If there's a assigned storage closet, which many condominiums have, put it on the other line. If there's ownership in anything, let's get it in writing and get it part of the contract. Inspections and repairs. Number 9. The rights and obligations arising under paragraphs 11 and 12 of this contract to maintain, repair, replace, or treat are limited to seller's individual condominium unit, and unless seller is otherwise responsible, do not extend to common elements, limited common elements, or any other part of the condominium property. Number 10, governance form. Pursuant to Chapter 718 Florida statutes, buyer is entitled to receive from seller a copy of the governance form in the format provided by the Division of Florida Condominiums, Timeshares, and Mobile Homes of the Department of Business and Professional Regulations, summarizing the governance of the condominium association. Okay. Any questions on the condo rider? This is very important whenever you're dealing with a condo transaction. Right. Moving right along then. HOA disclosure. Okay. Anytime your property is located in the HOA, you must have one of these for proper disclosure attached to your transaction. Okay. This line needs seller's name. This line needs buyer's name. These two lines are for the property. We need buyer's initials. We need seller's initials. The name of the community. Okay. Number 3 here, the first fill in the blank. Down here, you will be obligated to pay assessments to the association. Assessments may be subject to periodic change. If applicable, the current amount is blank per blank. Is there an assessment of, $100 per month, or is there an assessment of $300 per quarter? Whatever it is, enter the amount and the time period that it's charged. You will also be obligated to pay any assessments imposed by the association. Such special assessments may be subject to change. If applicable, the current amount is blank per blank. So if there's a special assessment, you know, did they just have the roof done? Did they just have their condo paved? Did they just have carports installed? Was there anything at all that imposed a special assessment? If so, enter it there. Okay, number 6 down here, the next fill in the blank. There may be an obligation to pay rent or land use fees for recreational or other commonly used facilities as an obligation of membership in the homeowners association. If applicable, the current amount is blank per blank. So if that's applicable, enter in the fee and the amount there. And then lastly, you will need buyer's full signature and date here for proper execution of that document. Okay. Don't forget page 2 of the HOA doc. I see it all the time. Okay. Approval. If association approval of this transaction or the buyer is required, this contract is contingent upon association approval no later than blank days prior to closing. Okay, by default, it is 5 days. So if you need excess of 5 days before, be sure that you enter something there. Within blank days after the effective date, the seller shall initiate the approval process with the association. Again, by default, that's 5. So if you're in an HOA that requires more than 5 days, make sure you fill in that blank. Okay. Down here, payments of fees, assessments, and other association charges. Yes, we had it on the first page, but right here, it might seem a little bit redundant, repetitive, whatever you'd like to call it, but you need to do it here too. So is there a $100 charge per month for master HOA to Talus Park? Is there a $200 fee per quarter for sub HOA to, whatever the sub HOA might be called? Is there a food and beverage minimum required per year for food and beverage minimum to the clubhouse? Okay, any of those fees need to be disclosed here. Okay, if levied, special or other assessments exist as of the effective date, or an assessment is levied after the effective date and prior to the closing date, and any such assessment may be paid in installments, then seller shall pay all installments due before closing, and buyer or seller, you need to choose one, and if you leave it blank, then buyer shall pay installments due after closing date. If seller is checked, seller shall pay the assessment in full prior to or at the time of closing. Okay, make sure you pay close attention to this. The association or management company to which assessments, special assessments, or rent land use fees are due and payable is or are, name them here. Okay, maybe it's Master Association at Talus Park. Contact persons John Smith, phone number 239-555. You get the idea. If there's a sub HOA, what's the sub HOA? What's their phone number? How do we get in touch with them? Also, if the HOA has a website, list it here. Don't be the lazy realtor that never fills out the second page of the HOA. Disclose, disclose, disclose. Any questions on the HOA disclosure? Okay. Seller financing. Not too common, but if you do run across a instance where where you're utilizing seller financing, then we need an addendum for that. Okay. Right here again, seller's name, buyer's name, property address, buyer's initials, seller's initials. And then you go through this right here, and line by line, you can specify the terms that the seller is requesting. Okay. and give this to the seller to fill out, or meet with your seller and go over this with them line by line and just fill in the blanks. Okay, seller agrees to hold a note secured by, is it a first or is it a second purchase money mortgage? Executed by the buyer in the principal amount of blank at blank interest rate per annum. If you have any questions about this, feel free to reach out to me. I'm happy to help. Also, you know, a lot of times when there's seller financing involved, a lot of times the seller will also have an attorney involved in that transaction. And of course, the attorney will fill this out for your seller. I'm not going to spend a lot of time on that. Not too common in the market that we're in right now. But again, any questions, feel free to see me anytime. Okay, same is true with this one, not very common right now. Assumption of existing mortgage. Yes, if the seller has a mortgage that is transferable and buyer would like it to be transferred, then yes, it's possible. And we just need the addendum of assumption of existing mortgage. And this has to be filled out. And again, a lot of times when something like that is involved, an attorney will also be part of the transaction. All right, here's one that we should be very familiar with. All right, Federal Housing Administration, FHA, or U.S. Department of Veterans Affairs, VA. We've all worked with FHA buyer or a VA buyer, and if you haven't, spend a little more time in the business, you will. First line, seller's name. Second line, buyer's name, property address, buyer's initials, seller's initials. Okay, inspections and appraisals. Appraisal repairs not to exceed blank, which cost is in addition to the cost required to be paid under paragraphs 9A and 12B. All right, so enter a number there. A lot of times it's $0 or $100. And if it's FHA financing, make sure you check the box at number 3 here. FHA financing, it is expressly agreed that notwithstanding any other provisions of this contract, the purchaser shall not be obligated to complete the purchase of the property described herein or to incur any penalty by forfeiture of earnest money deposits or otherwise, unless the purchaser has been given in accordance with HUD, FHA, or VA requirements, a written statement by the Federal Housing Commissioner, Veterans Administration, or a direct endorsement lender setting forth the appraised value of the property of not less than blank. So enter the purchase price there, okay? The purchaser shall have the privilege and option of proceeding the consummation of this contract without regard to the amount of the appraised valuation. The appraised valuation is arrived at to determine the minimum mortgage. The Department of Housing and Urban Development will ensure HUD does not warrant the value or the condition of the property. The purchaser should satisfy himself, herself, that the price and condition of the property are acceptable. Fees and prepayments. Purchaser shall pay all loan expenses except tax service fee, which fee, if charged by buyer's lender, shall be paid by seller up to a maximum of blank. A lot of times this is $0. Appraisal repairs. Okay, if there's VA financing involved, make sure you check the box at number 4 there. Okay, and then both all buyer parties needs to execute, all seller parties needs to execute, buyer's agent needs to execute, listing agent needs to execute. Any questions about the FHA VA addendum? Okay, moving right along, appraisal contingency. Just like all the other addendums, seller's name, buyer's name, property address, buyer's initials, seller's initials. Okay, and if you have a cash buyer and they'd like an appraisal contingency, go ahead and include the appraisal contingency here. This contract is contingent upon the buyer obtaining at buyer's expense a written appraisal from a licensed Florida appraiser on or before such and such date. And if you leave it blank, then it's at least 10 days prior to closing, stating that the appraised value of the property is at least blank. And if you leave it blank, then the purchase price is entered by default. If the appraisal states that the appraised value of the property is less than the above value, buyer shall deliver a copy of such appraisal to seller within 3 days after the above date and deliver written notice to seller, either A, terminating this contract, in which the event of the deposit paid shall be refunded to the buyer, thereby releasing buyer and seller from all further obligations under this contract, or B, waiving and removing this contingency and continuing with this contract without regard to the appraised value of the property, except as provided in paragraph 8B, if it is checked. If buyer fails to timely obtain an appraisal, or having timely obtained such appraisal fails to timely deliver notice of buyer's exercise of the right to terminate granted above, this contingency shall be waived and removed, and buyer shall continue with this contract without waiving any of the buyer's rights in paragraph 8B, if it is checked. Any questions about an appraisal contingency? Short sale approval contingency, okay? The same is true on this addendum. I'm not going to spend any time on the top here. You've heard me say it enough. Short sales aren't too common right now. You know, if and when the market turns again, these may become common again, and we may have to revisit those. But for the time being, if you have any questions about short sales and approvals and the contingencies that should be used, feel free to see me at any time, but we're not going to spend any time on that this morning. Homeowners or flood insurance, okay? You can include an addendum that will give a buyer another out, okay? Homeowners insurance and flood insurance, basically set the cap. You know, if it exceeds, let's say it's $2,000 a year, buyer's got the right to cancel and get a refund of their deposit. Flood insurance, again, enter a cap or a percentage, okay? And you also have to have an expiration date of the buyer's right to move forward with this as well. But you know, it's an additional out. So if it's in a flood zone and buyers, you know, very tight with their expenses, you might want to include the flood insurance addendum here that gives them another way to cancel the contract. Any questions on that? Okay. Interest-bearing account, again, we know how to execute the top of this now. If deposits are held by an escrow agent in an interest-bearing account, then by law it has to be disclosed. Name of the financial institution with all accrued interest to be paid to what party at closing, okay? Deposits shall accrue interest only from the date the financial institution receives and credits the deposits through the date escrow agent is notified that the transaction is scheduled for closing and the funds are transferred. Escrow agent is authorized to deduct blank as a service charge from the earned interest rate before dispersing the funds. Not very common. However, I have had firsthand experience at least once utilizing this, so it's a good idea to have some familiarity with it. Okay, as is addendum. You know, if you presented on the Florida FAR Bar standard sales and purchase contract during negotiations, one party may opt to move the to an as is. Okay, make the transaction as is, the purchase as is. If so, no need to go ahead and rewrite the whole contract on an as is contract. We can simply add this one addendum, which will convert the contract to as is. Okay, we still include the inspection period on here. Any questions about that? Moving right along, right to inspect and right to cancel. In lieu of the inspection period set forth in paragraph 12A, buyer shall have blank, if left blank, then 15 days from the effective date, right to inspect, within which to have such inspections of the property performed as buyer shall desire, and utilities shall be made available by the seller during the right to inspect period. Any inspections permitted under paragraph 12, which buyer desires to make, must be completed during the right to inspect period. Okay, so this will give the buyer the right to inspect and right to cancel the contract. So this is additional protection that you can add to a contract. Any questions about that? Feel free to reach out anytime. Defective drywall, okay? During certain time periods, defective drywall was a big issue here in Southwest Florida. So if you are dealing with a property in that time period, if my memory serves me correctly, it was most prevalent around 2005 to 2008, plus or minus maybe a couple of years, and especially in townhomes and condo buildings that they were really putting up quite quickly. But if you would like added protection about defective drywall and another way to protect the buyer and get the buyer and out to the contract, you can add this to your contract as well. Any questions about that? Okay. Coastal construction control line. If you're dealing with a property, you know, we have tons of waterfront property here in Cape Coral. Not much, if any, is affected by the coastal construction control line. I'd like to share this with you. And this area in red here represents the coastal construction control line. And you can see that it's everything that's out there that if something coming in from the Gulf were to try to come on land, it would hit this coastal construction control line before it came into land. So all of that area is protected, and you will be required to use that disclosure if your property falls within that region. Okay. Any questions on that? Feel free to see me anytime. Installation disclosure for new residents. Installation has been or will be installed in the new residence as follows. Okay. So a lot of times, you know, maybe you're working with a builder or new construction, you know, as a buyer's agent, you can request that the builder fills this out. Again, it's additional protection for you and your buyer. Lead-based paint disclosure. Okay, we will, I promise you, you spend some time in real estate in Florida, you will use this addendum and make sure that it's filled out properly, because any mistake on here can be a fine of up to $10,000 per instance, or I should say per error on this, not per instance, but per error. So there's multiple places for initials on here. Let's say you missed an initial. Every initial that's missed can be a fine of up to $10,000. I don't say that to scare you, but when you fill out these forms, you need to take your time, be aware, and make sure that they're done correctly. Okay, so the top part's like any other one. Okay, on this part, seller's disclosure. Presence of lead-based paint or lead-based paint hazards is either known or seller has no knowledge. So select one of those two boxes, have seller initial. Records and reports available to seller. Seller either has provided or does not have any reports or records. Check the appropriate box, have seller initial. Buyer's acknowledgement. Buyer has received copies of all information listed above. Initial. Okay. Buyer has received the pamphlet. Protect your family from lead in your home. Initial. Okay. Even if the buyer or the seller does not have any copies of anything to share with the buyer still must initial line C. Buyer has, check one below, either received a 10-day opportunity or other mutually agreed upon period to conduct a risk management assessment or inspection for the presence of lead-based paint or lead-based paint hazards, or they've waived the opportunity to conduct such inspection. Check the appropriate box, have buyer initial there. Okay. Licensee has informed the seller of seller's obligations. Okay, listing licensee, make sure you initial here. Okay, seller parties, full signature and date. Listing agent, full signature and date. Buyers, full signature and date. Buyer's agent, full signature and date. Okay, I realize Coldwell Banker has their own version of this, and it's a bit easier to use. We don't have all of the other initials. We simply have the signatures at the bottom. Coldwell Banker didn't want the liability of a $10,000 fine per each and every line. However, you need to be aware of this because you will work with other non-Coldwell Banker agents, and you will be presented with this. And it's just good business to become familiar with the addendums that are out there. All right, many questions on the lead-based paint disclosure. Okay. Moving right along, housing for older persons. Okay, maybe you have sold a property in a 55 and better community, an age-restricted community. Anytime you have a transaction involving in a property in one of those types of communities, you need to include this disclosure. Okay, top part like any other one, but down here, is it for, does it have the exclusion for 62 years or older, or does it have the exclusion for 55 years or older? All right, rezoning contingency. Here in Cape Coral, we do have some properties that may need to be rezoned. If that's the case, then make sure that you include this contingency. Lease purchase or a lease option, not too common in the market that we're in today. However, if you do come across a seller that may want to offer that, then be sure to include this addendum. Pre-closing occupancy by buyer, not very common, but yet I do have experience with this firsthand. If you come across a transaction where you may need to implement this, make sure you utilize this addendum. Okay, so if buyer needs to move in before the property is closed, be sure to include the pre-closing occupancy by buyer. Okay, let's say that the seller needs to stay in the property post-closing. You know, a lot of time that can happen. Make sure that you include the addendum that outlines what is required and who is responsible. Sale of buyer's property. Ooh, boy, we get a lot of this in the market that we're in today, don't we? The top part, like anything else, okay? Seller's name, buyer's name, property address, buyer's initials, seller's initials. Here we go. This contract is contingent on the sale and closing of buyer's property located at such and such address. Upon entering into a contract for the sale of buyer's property, buyer shall give seller a copy of such contract with the third party's identification and purchase price information obliterated. If the sale of buyer's property does not close by such and such date, buyer may, within 3 days thereafter, deliver written notice to seller, either A, terminating this contract, in which event the deposit shall be refunded to buyer, thereby releasing buyer and seller from all further obligations under this contract, or B, waiving and removing this contingency and all other financing contingencies and continue with this contract. And let me just tell you, failure to deliver notice is option B. You will waive and remove this contingency and all other financing contingency and continue with this contract. So if you are representing a buyer and you include this contingency, be very mindful of your dates so that you are in compliance. Do not cost a buyer their deposit if you go past that 3 days. Any questions about that, please see me. Buyer's property is or is not presently under contract for sale. If buyer's property is under contract, buyer shall provide seller with a copy of the contract on or before such and such date. If you are a listing agent and the buyer's property is not under contract, then you are probably doing your seller a disservice if you ask them to accept a contract with this contingency. You have no idea if the property is priced correctly, especially if it's in an outside market. Also, you have no idea how that property is being marketed. And if you spend any time looking at expireds here in our market, you can know that properties can go a long time, years even, before they ever sell, especially if they're priced incorrectly. Okay, so just be very mindful about and very wary really about accepting a contract with contingency of sale of a property that's not even under contract. Any questions about this? Because we are seeing a lot of this in our market presently. Okay, see me anytime if and when you do have questions. All right, backup contracts, seeing a ton of this right now. Low inventory, these things are common. This backup contract is subject to the termination of a prior executed contract between seller and a third party for the sale of the property. If the prior executed contract is terminated and seller delivers written notice of the termination to buyer before 5 p.m. on such and such date, this contingency shall be removed and this backup contract shall move in first position. The effective date of this backup contract shall be the date seller delivers written notice of the termination of the prior executed contract. Buyer may terminate this backup contract by delivering written notice to the seller prior to the date seller delivers written notice of the termination of the prior executed contract, and the buyer shall be refunded the deposit, thereby releasing buyer and seller from all further obligations under this contract. If you're submitting a backup contract for a buyer, make sure that you include this addendum, okay? Also, if you have presented the backup contract and your buyer has decided against the property with this and they've decided to pursue another property, make sure you deliver written notice to that seller so that you don't risk your buyer going under contract with more than one property. I've seen it done. Don't let it happen to you. Any questions about that? Kick out clause. All right, starting to see a little bit more of this with our low inventory. Let's see what it is. Seller will have the right to continue to show the property and solicit and enter into a bona fide backup purchase contracts with third parties that are subject to the termination of this primary contract. Upon entering into a backup contract, seller will give buyer a copy of the backup contract with the third party's identification and purchase price information obliterated, To continue with this primary contract, buyer must make an additional deposit of blank to escrow agent within 3 days from receipt of the backup contract. By giving the additional deposit to the escrow agent within 3 days, buyer waives all contingencies for financing and sale of buyer's property, and the parties will close on closing date. The additional deposit will be credited to buyer at closing. If buyer fails to timely make the additional deposit, then this primary contract shall terminate and buyer shall be refunded the deposit, thereby releasing buyer and seller from all further obligations under this contract. Seller's attorney's approval. Okay, maybe you're the listing agent and the seller would like to have their attorney approval. No problem. Include the right addendum in the contract as part of the transaction, and then you have an expiration date of this addendum as well. Buyer wants their attorney approval. No problem. We've got an addendum Z, buyer's attorney approval for that, and again, there's an expiration date to this. Okay, licensee disclosure of personal interest in property. Okay, by law, if we have interest in a property, we need to disclose that, and lo and behold, we've got an addenda for that as well. Addendum AA. Okay. Also, you know, maybe whoever you're representing is a real estate agent. However, their license is in an inactive real estate, is inactive. So they hold an inactive real estate license. They still need to disclose that. Use the addendum. Okay. Binding arbitration. Let's hope we don't have to deal with this ever. But if initialed here by both buyer and seller, any dispute not resolved pursuant to mediation as provided in paragraph 16B of this contract shall be settled by binding arbitration using the real estate industry arbitration rules of the American Arbitration Association, unless the parties mutually agree to use other arbitration rules. The arbitrator may not alter the terms of this contract nor award any remedy not provided for in this contract. The parties shall be allowed discovery in accordance with Florida rules of civil procedure. Okay, so get attorney advice on this, but you know, my understanding is, you know, we're going to prevent a lawsuit and things of that nature, that if any problems arise, we will go to arbitration in lieu of other disciplinary or corrective legal actions. Okay. And that's everything that I have for you in my addenda and riders. If you do have any questions, feel free to see me or reach out to me at any time. Also, you know, make sure you've got a good title company on your team. You know, we've got Sunbelt Title here. Tracy Barkhausen has been excellent. Cindy Dunn's excellent. Anybody with Sunbelt, Jennifer, Anita, you name it, they're here for you. And like I said, don't feel that you can only go out to title when you have a question about closing. Title's here for you, and a lot of these things that we went over today, title is going to be involved very thoroughly with these things. So if you have questions, reach out to me, reach out to title, reach out to an attorney, build your team. We're here for you. Reach out anytime. But thank you for joining me today and attending this training, and be well. Thank you.